We've got a nice crowd here. Thanks for coming and welcome. My name is Bill Banks. I'm the director of INSCT, and it's a real pleasure today to have a panel of really knowledgeable experts on a substantive problem in national security law called the state secrets doctrine problem, but also a distinguished guest who's with us from Washington, along with two of my colleagues. So I'm going to be very brief, get us started, and turn the floor over to our panelists after a brief introduction. For those of you who are unfamiliar with national security law so far, the state secrets doctrine springs from an evidentiary privilege. You're all taking courses in civil procedure and perhaps in evidence by now, and you know about common law privileges. This is one of those in its, at least in its infancy it was, and now it's, I think, bigger than that, and certainly has a lot of consequences. In the news this fall are disputes revolving around the use of the state secrets doctrine by the government to prevent the release of information in a lawsuit challenging the constitutionality of the no-fly list, and another one that involves a lawsuit among private parties where the government itself is not even part of the litigation, yet the government is considering invoking the state secrets privilege. In 2009, in one of the first months of the Obama administration, actually it was in September, Attorney General Holder issued a memorandum adopting policies and procedures governing invocation of the state secrets privilege. It was the first time in the United States that the government had purported to sort of regularize the way that that state secret doctrine would be used in litigation. And that that memorandum is publicly available. A couple clicks on Google will bring you to it. It's a 5-page or so document, and it purports to say we're going to be very careful, we're going to be very transparent, we're only going to invoke the doctrine when we have to, and when we do have to, we're going to invoke it narrowly, trying to preserve as much of the record for public transparent release as is possible. It's not clear how that memorandum has impacted the government's role in state secrets disputes over the last 5 years, nor how it might play out in these two matters that I mentioned just a moment ago. It's a complex and troubling area of the law because the interests on either side are often controversial and disputed, contested, and because the historic development of the doctrine itself is a bit clouded, and in some respects is based on an unfortunate history of, in the Reynolds case, the one that sort of gives birth to the modern doctrine, a government effort apparently simply to cover up its own negligence. So not a happy basis for the modern doctrine, but it's alive very much. I don't know whether I want to say it's well, but it's certainly playing out with a lot of importance here today. So, as I said, the panel is all expert in this question from various experiences and backgrounds, but let me especially begin by introducing our out-of-town guest, Mr. George Jameson, who's been with us now. Is this the 4th time?
I think so.
Right. We're going to make him a member of the faculty, I think.
Sounds good.
Comes up regularly. George had a more than 30-year career in the Central Intelligence Agency and the U.S. intelligence community as a senior counsel, as director of the CIA's Policy and Coordination Office, and had a role in managing congressional affairs at the agency and at the Office of the Director of National Intelligence. His responsibilities in the agency included reviewing the legality and propriety of operations, including covert action and counterterrorism, war crimes issues, foreign relationships, Information and Privacy and Intelligence Community Policy and Reform. George is now a private consultant. He's also an adjunct staff person at the RAND Corporation, and he's chair of his own nonprofit called the Council on Intelligence Issues. I think you all, or nearly all of you, must know Professor David Crane to George's left, who's been here for several years as a professor of practice in his own right, had a distinguished career in the intelligence community. And to David's left, our newest colleague at the law school, Professor Nathan Sales, who was at DHS, Department of Homeland Security, had some exposure to intelligence issues before he entered the academy. So each of the three is going to comment on these matters for a few minutes. We'll have a discussion, Q&A from you, of course, and I think we can get it all done and get out of here before the next class crashes in about 10 minutes to 1. So George, the floor is yours.
Thank you. Thank you very much. Thanks for the invitation and kind introduction, and thanks to all for coming, and I'm looking forward to the discussion. It's nice to go first because I can leave all the hard things for them. And so I just have a few things I'd like to say before passing it on. First, two general matters. Despite what many would think, these kinds of questions, state secrets questions, are really legal, not political. I know that may be hard to believe, but there's kind of a sense out there, whether it's in dealing with state secrets or dealing with leaks or anything else. Well, this administration is going to be different from the last one, so as a political matter, they're going to be dealing with things in a very different way. And supporters, as well as opposition, tend to be very surprised when, in fact, president after president, Justice Department after Justice Department, agency after agency, whatever the administration, they don't really deviate all that much in application of the law, because it's the law, it's not politics, general rule. Second is that in my experience in dealing with state secrets and other claims of privilege, and one of my jobs was chief of the CIA's litigation division for a number of years, at least with respect to CIA, and I have less knowledge about other agencies, but I've never seen people taking steps to claim privilege or cover up information strictly for the cover-up. It's while there may be mistakes that people make, while there may be confusion about what information people have, and while there may be differing interpretations, I've never personally seen bad faith. I tend to ascribe problems that people have more to bureaucracy and incompetence than to malevolence, and that's from my experience. Those are just general introductory remarks. With respect to claims of state secret privilege, let me say the following. The privilege is there ostensibly for a common good, a greater good. And as a nation, we recognize, as you know, many privileges. There's the attorney-client privilege. There's the spousal privileges. There's the confessional. We also allow, and this kind of gets to the politics or the non-legal concerns that people raise, we also know that in our legal system, we're not always going to have fairness. We seek truth, justice in the American way, and we seek fairness, but it doesn't always end up that way. And that's as a matter of law. Miranda warnings are designed to remedy one problem, but it can result in an unfairness in the eyes of many if a guilty person gets off. Failure to file timely claims or timely appeals can result in an unfairness to a complainant. We know that. That's the way the system is set up. Eminent domain, you can argue, oh, there's compensation, but if somebody has family property that's in the way of the highway, it can be unfair to that person to lose the property and get in return only a piddling sum. So the system, and I won't even talk about the electoral college. So the system has unfairness as a matter of our DNA as a nation. Next, we also know we have constitutional rights, but we restrict them, whether it's restricting speech, defamation actions. If you had absolute right to free speech, you could defame somebody. You know you can't. Not even the press has an absolute right to defame somebody. Travel, liberty, the kind of stake that's raised in the no-fly list. Political activities of government employees, and there are more. So simply saying, well, it's my constitutional right, I should be reimbursed or for the problem, is not necessarily going to solve the answer from a legal perspective. We also recognize that in some cases, political questions, constitutional political questions based on separation of powers, are simply not going to be resolved. The courts and the executive and the Congress have independent powers, independent rights, and in some rare instances, there's not going to be a remedy for whatever the wrong may be. So where this brings me in the discussion of these cases and others is that we have a legal question. And the legal question is, how does the court become satisfied, per Reynolds, that the state secrets interests really are at stake? What are the state secrets interests? How is a court going to become satisfied, particularly when you have separation of powers questions? We have the executive urging in-camera review at best. Sometimes they don't even want to turn over the information. And in a true constitutional battle, that might have to come out as stalemate. And it can depend on who's got the information. If the government has it, it has the upper hand. It may not have to give it up. If another party has it, different situation. The Justice Department, in at least one of these cases, made it plain that it wanted to take wanted the court to consider multiple remedies. And so the results in any of these cases, from a state secrets privilege perspective, protecting the national security of the United States is to protect the public good, you protect the information. And the courts are not supposed to balance according to precedent. The private good, then, potentially gets left in the lurch. The only thing I would say to that is, beyond what I've said about the system, there is always a public remedy for a private wrong. And that is, Congress can pass a private bill, depending upon the circumstances, particularly where the government is accused of wrongdoing and the facts can't come out. Nothing stops somebody from going to Congress and saying, I was wronged. Congress then can enact the law, the executive can sign it, and nobody has to admit fault, nobody has to reveal secrets. So that is one way for those who are less concerned about the law and more concerned about equity to find a solution.
Good. Thank you, George. David.
I'll kind of preface my remarks, and I'm coming at this not as a professor, but as the former Deputy Inspector General of the Department of Defense and Director of the Office of Intelligence Review, which was part of my charter, was basically overseeing about 80% of the U.S. intelligence community. And but I want to step back and just pause and have us think about, throughout our history, there's always been this tension between national security and civil liberties. And the Constitution and the various laws that the Congress passed were the balance between this stress and strain of national security and civil liberties. Legislatively, Congress, aware of these stresses, have granted extraordinary powers to the executive under certain circumstances, but they always caveat that with certain limitations, because they do recognize the executive has to do certain things in order to protect the nation through our national security. But through those required checks legislatively, such as intelligence oversight or federal court review of certain things, such as the Foreign Intelligence Surveillance Act, or even something as simple as sunset provisions. We'll give this to you now, but in a year or 3 years from now, you got to come back and explain to us why this is still important to us. But in the past 10 years, or since 9/11, in some ways, the wheels came off in that delicate balance. And it's a very subtle shift towards national security, and in some cases even classified. And with that, when we're talking about state secrets, there's an unease, I think, beginning to develop that I've not seen in quite some while. And the courts are beginning to actually question it a lot more closely than they would if, let's say, for example, the government was seeking what we call a totem bar, which is an absolute bar. The case ends if they invoke that particular bar, or if they want to keep certain evidence out, such as a Reynolds bar. It may preclude litigation, or it may not, but certain evidence will be kept out for national security. And, the standard has always been, under Reynolds, was the courts look at all the circumstances related to the government position, and they have to find that there's a reasonable danger that state secrets will be divulged. So there's a lurking sense within some of the circuits that there's a sense of overreach, that there's something going on here more insidious than just the appropriate privilege of a government wanting to do business in this very dangerous world of ours, and that there are just certain things that the American people don't have a right to know, because they do know, and there's other exceptions on many other acts, then operatives, nations, sources, and methods would be compromised, and our national security would be compromised. So it's rare that we have such a thing as for example, a totem bar itself, where the courts literally roll over, say, all right, we're satisfied. There's a certification from the Attorney General, or along with a certification from the Director of National Intelligence or the Secretary of Defense, whomever, saying you can't reveal this. And we have an interesting development here where we actually have a federal district court judge who's actually demanding the evidence, and he wants to see the evidence. That's potentially a beginning. I'm not sure how far that's going to go up the circuit, so to speak, but that's beginning of a test related to, I believe, the totem bar. So anyway, with that being said, I kind of picked up on a point that George made. Yeah, this is a legal privilege. It is a privilege that's important, particularly to the executive branch. It is one of those carve-outs where that balance that is given between national security and civil liberties is legislatively given by the legislature to the federal or to the executive branch. And it is a legal point. But because of the sensitivities that we're hearing about potential government overreach, like the electronic surveillance program, allegations related to rendition, secret prisons, what have you, I think we're going to continue to see a testing of the limits of the state secret privilege and the power of the executive constitutionally to do things all in the name of national security. And as I've told my national security class, when your client comes to you and you ask him, what authority do you have to do this particular operation? The answer from your client is never, well, it's for national security purposes. That's not an authorized basis by which we conduct our intelligence operations or other types of operations that are clandestine. That's never a legal basis to do so. So with that, I'll just stop and look forward to your questions.
Good. Nathan?
Thanks, Bill. Thank you all for being here. So I wanted to offer a couple of observations about the trend, who knows if it's a trend, represented by the no-fly list case, in which we see a court engaging in intensified scrutiny of the government's invocation of the state secrets privilege. My bottom line takeaway from this is that intensified judicial scrutiny is a flawed solution to a very serious problem. The very serious problem being overclassification or improper classification of information that really has no business being kept under wraps. So Bill mentioned there are all sorts of reasons why government officials will seek to classify information. Some of them in good faith and some of them in not so good faith. The good faith reason is the obvious one. well. If we compromise our sources and methods, there will be grave harm to our intelligence gathering capabilities. If we compromise the intricate details of behind-the-scenes diplomatic negotiations, our foreign affairs will be compromised and complicated. So information that's classified for those reasons, assuming that it's properly classified, right, by definition should be kept under wraps. If its release would cause grave harm to the national security or serious harm to the national security or whatever the standard is, that's a strong reason, not a conclusive reason, but a strong reason for it to be kept under wraps. The difficulty arises because standing alongside these good faith reasons to classify information, we have a whole host of bad faith reasons for doing so. Government officials will sometimes seek to classify information to avoid embarrassment. Right? They screwed up and they don't want other people to know about it. Could even be to the level of a cover-up, right? To cover up not just embarrassing behavior, but illegal behavior, misconduct. Sometimes bureaucrats classify information as a way of preserving their turf. They want to maintain their responsibility for dealing with a particular issue and exclude others who might be bureaucratic rivals to them from starting to dip their toes in the same waters. So overclassification is, I think, a truly serious problem. I have some reservations about using enhanced, intensified judicial scrutiny of invocations of the state secrets privilege as a way of solving this problem of overclassification. So the doctrine, I think Bill mentioned this, the doctrine is that if the government invokes the state secrets privilege successfully, the information is absolutely privileged from disclosure. So it's a privilege that runs to the information. Right? So it's different from totem in this respect. In totem, if totem is successfully invoked, the remedy entered by the court is to dismiss the plaintiff's lawsuit altogether. Under the state secrets privilege, the lawsuit can continue. It's just that you don't have the ability to access the information. Practically speaking, those two doctrines can often produce the same result. Right? Because if under the state secrets privilege, if under Reynolds, the court refuses to order the government to turn over the central information to your case, the case can go on, but there's really no point in it anymore, right? So why have courts traditionally been extremely deferential to the executive branch when the state secrets privilege is invoked? I think there are two reasons, and these reasons emerge when we contrast the doctrine of the state secrets privilege to other doctrines and other principles that govern access to classified information. So, for instance, consider SIPA, the Classified Information Procedures Act. When courts apply SIPA, we actually see a much more balanced, burden-shifting approach in which the government's interests are important but not conclusive. Why is that? Well, the SIPA problems arise in the wake of the government's decision to file criminal charges against the defendant. We think you committed a crime. The defendant will then, on occasion, seek to introduce or discover classified information. Once this dance has been initiated, there's a well-known series of back and forth maneuvers that take place. The government will say, well, we don't want to introduce the classified information, or we don't want to allow you to introduce the classified information. So how about instead of that, we admit to the facts in question, or we'll prepare an unclassified summary. Under SIPA, those substitutes can be introduced as long as the defendant retains substantially the same ability to represent his or her interests. Now, if that's not the case, if the unclassified summary wouldn't be as probative, then the government can refrain from allowing the evidence to be introduced, but at a cost. The court will at that point impose various different sanctions that range from dismissing the government's criminal complaint altogether, dismissing particular charges, finding against the government as to particular facts, or other types of remedies that the court might impose. That is a very, very different balancing back and forth framework than what we see under the state secrets privilege, under which the government's ability to withhold properly classified information is absolute, right? It's an absolute privilege. Why is that? I think it has to do with the distinction between the sword and the shield. When the government seeks to use classified information as a sword, as in a criminal prosecution, we're much more wary about the government's ability to keep that under wraps. In effect, the government has sort of opened the door by deciding to commence a criminal proceeding against a defendant. The government has waived whatever privilege it otherwise might have had to keep something out of the public eye altogether. It hasn't opened the door the whole way. It's trying to keep it partially closed, but it's made the cost-benefit calculus that proceeding with a public criminal proceeding and the inevitable risk to classified information is worth it. By contrast, in the state secrets context, the government is operating, trying to invoke the doctrine as a shield. Government didn't initiate legal proceedings, it's the defendant. Somebody's trying to impose liability on government officials or otherwise seek to judicially test the legality of what the government has done. In this situation, there's no opening of the door. There's no waiver on the part of the government. The government is rather being brought into court against its will, as it were. And I think that difference between the posture of the cases and the difference between sword and shield helps explain why courts traditionally have been much, much more deferential in the state secrets context than they are in SIPA or other scenarios. So if robust, and I'll end with this idea, if robust, intensified judicial review isn't the best solution to the problem of overclassification, what can we do? Well, instead of a judicial remedy, I'd prefer to see a legislative remedy or an administrative remedy. What could that look like? Well, one thing that we should like to see, one thing we should see is a decrease in the number of government officials who have the authority to classify information in the first place. Another administrative or legislative remedy would be presumptive declassification of information on dates certain. That's actually in the relevant executive orders, but it's a fairly lengthy term. Information is classified for, I can't even remember, it changes so with every administration. That is one thing that does change with incoming administrations, the presumptive duration of classification. You can shorten that. You could also create some sort of, or enhance an adversarial mechanism. So if a government official sees information that has been classified but thinks, there's nothing here that's really harmful, there could be a review mechanism similar to a judicial process, an adversarial process in which the classification could be contested and then reversed. Different agencies have been experimenting with that kind of mechanism. I'd like to see it expanded a bit. With that, I'll stop. Look forward to some crosstalk on the panel and your questions.
Great. Very nice overviews from each of you. George, do you have reactions to Nathan's position on comparing the criminal domain to this one?
I absolutely agree. That's the distinction. I've seen some law reviews that have failed, that have looked at state secrets and really haven't dwelled on that point, but I've always thought that is exactly the reason when you're dealing with a SIPA situation. The government, in effect, has said we're willing to provide a limited waiver of our privileges. The other aspect of that is a kind of a due process aspect to it. If the government is going after somebody and the individual is in court and has no ability to defend himself, then we're dealing with secret charges, secret information that would be fundamentally unfair. Mm-hmm. There are a couple of other points. We can talk afterwards. I'm kind of curious to see where the examples are of overclassification to avoid embarrassment or turf. The examples that I remember the Brennan Center came up with tended to be from the 40s and 50s, and of course there are going to be some isolated instances. But as I said, that's not my experience. I think the big issue here in terms of how you deal with it is that's arisen since 9/11 is trust in government and the absence thereof for lots of different reasons, many of which I believe are unfounded. Loss in the faith of our elected officials, loss in faith that our overseers, the congressional overseers, are doing their jobs. I think it's outrageous, for example, when in the context of NSA surveillance programs, you have Congressman Sensenbrenner outraged when he says he says that I wrote the law. I know that's what we didn't intend. And then in the next breath, he concedes, but I avoided getting any classified briefings on the matter because I didn't want to be tainted by the facts. So it's awfully hard for anyone to have faith in a blanket assertion of government privilege when so many people are contributing to undermining the faith in the institutions that are designed to carry out these activities.
You know, a little pushback on on Nathan's suggestion that putting the courts in the middle of these disputes isn't the best way to go forward. You know, so federal judges, life appointments, neutral, don't stand for election, sworn to uphold the Constitution, and the opportunity that the privilege affords, just as the opportunity afforded by SEPA, is for in-camera review of sensitive government materials. Why not rely on that model, and why would the government object, say, in a case like the no-fly challenge, challenging the constitutionality of the no-fly laws? Why object to a judge reviewing in camera, that is, not in public view, the contents of the classified materials that form the basis for the program?
I guess there's two possible answers to that. One is judicial capacity and one is judicial role.
Mm-hmm.
So, and these are problems that I think would also arise in any other scenario where courts are called upon to balance the government's need to protect information with a litigant's need to gain access to it. So I think it would arise in SEPA as well. The judicial capacity point is courts really aren't as good at the executive branch, Congress, when they actually do their oversight, at figuring out whether the release of information would harm the national security. The executive tends to have a broader strategic lens and is aware of how disclosure in this setting might implicate activities in this seemingly unrelated setting. I don't know that courts have the institutional capacity to make those judgments. And there's also the question of judicial role, which is what happens if the courts get it wrong? If they withhold information that should be released, or if they release information that should be withheld. If some sort of national security harm results from a mistaken judicial decision in either direction, what is our mechanism to hold the courts accountable? We don't have one. We have a mechanism to hold the president accountable and Congress accountable. And the NSA controversy is a very good example of this. Congress has been moved to action and is considering legislative reforms to crack down on what many people regard as executive overreach. There's no comparable, well, there is, that you can impeach a federal judge who gets it wrong, but the channels of accountability are not as clear as they are for executive officials or congressional officials. I want to return to the point. These concerns about judicial capacity and judicial role are not unique by any means to the state secrets context. So why are we comfortable with courts playing this kind of role under SEPA and maybe not, in my view, comfortable with them playing an enhanced role here? I think it goes back to the distinction between sword and shield. And I've said too much already, but the other difference between SEPA and state secrets is who invokes the state secrets privilege. The doctrine is that it can only be invoked by a senior executive branch official, like a cabinet official. To move a cabinet secretary to do anything, right, requires an incredibly complicated, convoluted, detailed internal approval process. So the idea, I guess, is that internal executive branch review mechanism, culminating in an invocation by a cabinet secretary, is a substitute for a review by a federal court. Is it a perfect substitute? No, of course not, but it's not nothing.
I agree with much of that, most of it. One of the arguments I would make in favor of allowing more judicial review is that if the executive branch knows a judge is going to be looking at its material, its underlying basis, it's going to be a lot more careful. And the government doesn't like to lose cases. It will pull back if it thinks it doesn't have a case to be made. Having a judge as a neutral arbiter take a look at it can be helpful. Now, that doesn't mean that if, in fact, it's a legitimate claim of privilege, the executive won't say, you can look at it, but if you disagree with us, we're not going to release it. And when you hold the information, you're in a lot stronger position than you are if you're trying to keep a judge from, if you're trying to get a judge to keep somebody else from releasing it. But that adversarial process, that give and take, that oversight mechanism can be useful. And while I agree that institutionally, I would not want to concede that the courts can do it, certainly there are individual judges, and I'm thinking of one who, for whom I happened to work a number of years ago when he was the chief of the civil division at the U.S. Attorney's Office in D.C. He went on to become a judge, Royce Lamberth, and he is as capable as anybody of making those decisions, in my view. But I mention his name for another reason. I remember on a Friday afternoon, he would routinely talk to the Washington press person who was Washington Post press person who was doing the doing the court docket. And coming from CIA, I was on a rotational assignment to the U.S. Attorney's Office, and I had to say to him, after saying this time and again, I don't get it. You're talking to the press and revealing all of these things. For me at CIA, that was just a very odd situation to be in. And his answer to me, I remember, it was, if I don't talk to her, she will only get her information from the other side. And this way, I at least get the story across. And I lean towards thinking that way when dealing with a judge who's hearing all of this parade of horribles from one of the other parties to the litigant. Sometimes it can be helpful to say, look, we're not conceding we're going to give this information up, but we will open the door a little bit to give you a peek and make your job in ruling and giving us deference and ruling in the right direction that much easier. So it's a tactical. There may be some instances where strictly as a matter of principle you would never want to do that, but I think you look at them case by case.
That's great.
Bill, can I just?
Yeah, please.
No, I just, though I'm tempted to think, wow, maybe a federal judge should look at this, it came to mind as I was looking or thinking about the very important comments being made by my colleagues. You know, we actually have a system that we built into the foreign intelligence surveillance system. We have foreign intelligence surveillance courts that look at incredibly classified and deep programs to ensure that civil liberties are being maintained, et cetera, which is the very intrusive electronic eavesdropping against many individuals, to include U.S. citizens. So there's a model there, perhaps legislatively, that we might be able to look at if this becomes at that level. But I think we do have a system already in place that would, in fact, assure us as U.S. citizens that our civil liberties aren't being overreached, and that is, we have a very sophisticated intelligence oversight system made up of inspectors generals, general counsels, the intelligence committees of the Congress, and been doing this for decades. And I think that right now, absent some glaring abuse of the privilege, I think that the intelligence oversight system that were promulgated from revelations in the 70s and begun essentially in the Intelligence Oversight Act of 1980, I think are a sufficient counterbalance to ensure that there isn't overreach by the executive. I'm thinking of this from an operator's point of view as well. Boy, I don't know whether I'd want a federal judge, not an experienced foreign intelligence surveillance court judge who kind of is brought up and understands the significance of what he's looking at. But a federal court judge in some particular place in the United States looking at something that is so classified, so sensitive, I don't think he'd understand. He just wouldn't understand what he's looking at, let alone being able to professionally decide whether this is important enough that we're not going to let the world see that. And so that kind of sticks in my craw because I have a lot of faith in the intelligence oversight system because they look for this stuff. And there's an inspector general system. If there's an abuse, there are hotlines. There are ways by which you can complain that there's an abuse of a particular method or procedure that will be investigated neutrally. Inspectors general are sworn to neutrality, and they look into these situations. So even though my gut is that sounds like a neat idea, and yes, there is a comparable system under the Foreign Intelligence Surveillance Act. I think in situations like this, I think it's best left to the executive and the intelligence oversight system.
I think this is, it's your turn. It's time for questions. Heard some fairly provocative statements here and a lot of good, deep understanding. So let's have some discussion. Chris, wasn't that your hand up, or were you just
resting my head?
Well, don't do that again.
Yeah, so I guess outside of the CIPA context, so in civil litigation, if the government's going to assert the state privilege doctrine, how does the federal judge, or I guess the judge's clerk, really make the assessment on whether to let it go forward? What's the burden of proof, or what's the standard of review? Because CIPA lays it out very clearly, but in the civil context, it's really just precedent. So do you take the affidavit plainly for what it asserts, or do you have to ask for more?
Well, the issue really quickly is the certifying official in a state secret privilege. If you look at the actual certification, it's rather vague because you can't even say, even acknowledging it. And there's some things that even acknowledging the existence of it is deeply classified. So it's a very vanilla certification. It's basically that official asserting his professional career. Trust me, Judge, on this one. So that's why I'm beginning to kind of think, man, can you imagine a clerk of court handling top secret code word, going, doesn't even know what he's looking at, walking around a judicial building with, the idea is really becoming, practically speaking, this stuff has to be incredibly controlled. But so they won't be looking at right now, unless this trend seems to be moving, and I don't personally think it will. The actual handling of those documents, you're not even going to see them in a courtroom. They're deeply buried in safes under tight, appropriate procedural controls.
The legal standard, let me just get it on the floor here for those of you who don't know the case law or haven't read about the doctrine. This comes from Eric Holder's memorandum. It's a public document. The legal standard says the department will defend an assertion of state secrets privilege when a government, department, or agency seeking to assert the privilege makes a sufficient showing that assertion of the privilege is necessary to protect information, the unauthorized disclosure of which reasonably could be expected to cause significant harm to the national defense or foreign relations of the United States. Reasonably could be expected to cause significant harm to the national security. That's it. There's no more guidance than that.
But what happens is that invariably the government will file with the court a classified statement, a declaration, certification. There's a public filing, which is pretty bland, but there's a classified filing. And while and it's a very delicate balance that executives go through in trying to say enough without saying too much, and getting across to the judge what the problem is and why. Because the judges are not shy. They will ask, what does that mean? Why do you say that? Why should I believe that? And you have to make a pretty persuasive case, short of revealing everything. And sometimes you reveal quite a lot. Usually you reveal quite a lot, to persuade and to educate and persuade a judge. A judge who may never have seen classified information in his life will be educated by the government as to what that affidavit means, what that declaration means. And as I said, the judges are not shy about asking questions, and they need to be persuaded that in fact damage could result. Now, whether you get into exceptionally grave, significant, that's kind of the government to some extent will go through that process before litigating a case, because in your standard FOIA case, you're dealing with the same kinds of secrets, you're dealing with the same information, and you submit an affidavit, you submit an index, you classify justification, and judges make those rulings every day. This has just had something of more significance because of the rights of private parties and the equities that are at stake. So it's not a perfect process, and I don't mean to suggest that in every case a judge ought to absolutely see the underlying data to make those decisions. But in the way this works on a regular basis, the government makes the submissions, doesn't want to make an argument that it can't back up, is prepared to go pretty far to persuade a judge that, in fact, this information will be damaging. And then you get into a whole discussion about whether it really matters to the case.
Right.
Next question. Oh, come on now. Yes. Yes.
Now, Professor Crane, you pointed out that with a lot of these materials, you wouldn't necessarily feel comfortable having a judge deal with it due to the secretive nature and the complexities therein. With that said, this is more of a moral than a legal question, but should we actually be engaged in programs or activities that are so secret that the upper echelons of our society, with all the education and merits that come with it, can't even be trusted with it?
Well, now that's
an easy question.
Sounds familiar, Claxton. As Norm in Cheer said, it's a dog-eat-dog world, and we're wearing milk-bone underwear. It's a tough world out there, and there are things that the United States has to do to protect itself. And it's a concept that goes all the way back to George Washington. And even though our history shows that we've not been very good at it because of our abhorrence of getting our hands dirty, we have realized, particularly after 9/11, that we have to get our hands dirty in order to protect this nation. Now, I can assure you that these particular operations are reviewed for law, policy, and constitutionality. Just because they're special or are on the dark side doesn't mean that they're above the law. There is a very sophisticated legal review process, and so when the particularly appropriate authority authorizes something to happen, that is done under law as well as policy, and it's reviewed by general counsels, judge advocates. It's monitored by inspectors general, and so we do that. So why do we do it? Because we have to. I'm not saying it's the best answer, but we have to do these things in order to counter, to monitor, to find out what our adversaries, which are coming at us asymmetrically now. It's easy when you got the Wehrmacht or the Imperial Japanese Army coming at you, but it's a totally different situation when they're coming at you in ways that are still not even contemplated. And so we have to have the ability to be flexible enough under law to react. And some of that can be pretty dirty.
Let me address that as well. It's a good question, but it's kind of the wrong question, or at least it's only part of the question. If the question is, are there some things that are so secret that they should be kept from upper echelons of our government? Sure, absolutely. I think that's easy. There seems to be a mindset. There are some people who believe in open government to the fullest when nothing should be secret, and that's kind of silly. There are secrets in life that we all have that we want to keep secret, and we would say that's very important. They should be kept secret. And there are secrets of state that should be kept secret. And as I said in my opening remarks, there are a number of privileges that we as a society have recognized are important privileges where some things should be kept secret. The real question is not whether those activities should be kept secret from certain people in government. What I think you're really getting at is, are there some activities we should not be doing? That's a different discussion, and the answer in some cases may be yes. So how do you get a review of those things? And that's where I would get back to appropriate oversight, electing the right officials, making sure overseers conduct their oversight and not run away. I think oversight, for lots of different reasons, fell down post 9/11. Notwithstanding the views of many who are currently on the Hill who don't really like to talk about what they were briefed on or don't like to remember what they were briefed on. And I'm not going to speak to whether we should or should not have been doing certain activities, but if you don't have trust in your government, then there's a problem. And we don't, there are examples every day that would lead reasonable people to conclude there are things you should not trust. Just look at the news this morning on the trust me regarding Ebola and what's coming out this morning about the things that were going wrong, and notwithstanding people down in Texas officials are saying, oh, everything's great, just we got it under control. So it's a question of finding the right mechanisms, finding the right way to get the appropriate review. In some instances, it may be that when all else fails, someone would argue whistleblowers going public is the right answer. Other people would say that's the wrong answer. And this is where the legal argument turns into a policy discussion and debate about what are the appropriate principles that we want to follow, what are the appropriate remedies, what's the level of privacy we want to allow, and so on and so on. The public discussion becomes very important, and I'll finish by saying one of the big challenges we have, and I'm very interested in the challenges of leaks and things that I believe ought to be done to stem the flow of leaks. But one of the problems we have is the information that we all want to talk about is so tied up to the sources and methods that enable us to gather that information. We haven't found a good way as a nation to have a public debate about secret things. Members of Congress don't know where to draw the line. They either run away from it or they inadvertently spill information, so they say less. And there's nothing wrong with our elected representatives getting the classified information that they have and having a secret debate in Congress about the propriety and legality of activities that the public at large wants to know more about, and having that debate in a way that doesn't tell the public exactly what's going on. That gets back to you, to trust your elected officials or you don't.
George, you bring up a good point. The intelligence committees, which are Congress's way by monitoring the U.S. intelligence community, has disappeared over the past 10 years. And I've noticed over the past, comparing and contrast when I was working with those committees and the committees now, they were established to be bipartisan. That politics was not supposed to be involved in the Senate Select Committee on Intelligence and the House Permanent Select Committee on Intelligence. But I've noticed that they've become increasingly more political. And so these members who were supposed to be, not to take politics out of this and look for the national good of the American people, are now starting to politically calculate their response. And I think this is an important and subtle point that I think George very brings out, which is important, is that I think Congress has fallen down in its oversight responsibilities vis-a-vis the Constitution in these really challenging past 10 years. Compare and contrast in the 70s, when they dragged the entire executive branch before them and said, what's going on with the things that you're doing in the names of national security during the Cold War? And we had the Church Committee and the Pike Commissions and all of these various, the Rockefeller Commission, literally publicly making important questions. We've not seen any of that since 9/11, and I think that debate has to be had both in a classified way but also a public way. Let the American people decide whether this has been good or bad for the national security of the United States.
Who's next? Yes, ma'am.
I'll push back a little bit on the idea that judges lack the institutional competence to handle these questions. I think federal judges handle much more complicated and complex matters, and when the matters get so complex or the data gets so voluminous, they push it out to the parties, to the government to simplify the issues for them. And I guess I don't see evidence after 9/11 of judges being. I would actually argue that they're too conservative, and that that's part of the problem. And that what we ought to do is try to figure out ways to make judges more independent and to make them a more robust sort of filter. But I don't think the solution is to reduce the number of situations where you have the executive explaining to the government, explaining to the judge rather, why something shouldn't be released. I mean, there are plenty of federal judges who get the necessary security to be able to classify clearance, to be able to review the documents. Their law clerks get that clearance. They do review documents in secure facilities. So this happens in cases, and I don't know of situations where that's been abused or where there's really a problem that can be pointed to. So I guess I just push back a little bit on that.
So too conservative, you mean deferring too easily or too often to the government?
Yeah, over-classifying.
So a couple quick thoughts in response to that. So you're a federal judge. The question is, will release of this information cause exceptionally grave harm to the national security or significant harm to the national security? I don't know any way for a judge to answer that other than to say, all right, CIA, what do you guys think? So this actually raises a harm running in the opposite direction, a concern running in the opposite direction. The rubber stamp concern. Right. So my concern is that because judges don't really have the vocabulary or experience to differentiate magnitude of harm to the national security that's likely to result from a disclosure, the inevitable response of a judge is going to be, well, the executive branch says so. Why is that harmful? Because now we've sort of put a veneer of legality over top what is ultimately a discretionary decision by the executive branch. And I don't think judicial review is meaningful in those circumstances. And in fact, I think it's harmful because it gives a false impression that a neutral and detached magistrate has gotten into the weeds and blessed it, when in fact, more often than not, it will simply be a judge washing his hands and saying, whatever you guys want. This is the Chevron doctrine in administrative law, by the way. We can't figure out sulfur emissions, so EPA, have at it, right? And I'm worried about the same sort of dynamic in a national security or classified information setting.
That's been kind of the grumbling too with the FISA courts, and that is just are they rubber stamping just the warrant search, and it's an issue that kind of rumbling. There's been very few times, I don't know of any actually, that's not been approved. Now that's because the rigorous oversight that goes through that. So when it finally goes to the court, the executive branch has its act together related to electronic eavesdropping on U.S. persons. But from an outside point of view, that's the grumbling that the FISA court is really rubber stamping and in cahoots with the government and just making these things happen. So I kind of tend to agree with you.
Let me sorry, go ahead.
Yeah, I have to say, I've never had the thought that judges are rubber stamps for anything the government has wanted to do, whether it's the FISA court or otherwise. The notion that I have also does not contemplate that the judge gets to review and actually, I mean, judges will want to make decisions, but I believe that they should defer. But they have to be rigorous in extracting from the government the rationale and then defer at the end of the day on that judgment. But they have to be satisfied that the judgment, that the government has made a viable case. And it's a fine balance, and I'm not urging that we open up all these things for the judges to be making decisions. And at the end of the day, I think the reason for the deference is rooted in our constitutional underpinnings. It's a separation of powers question. If it's the government's secrets, the judge, at the end of the day, Ford vetoed the FOIA. President Ford vetoed the FOIA. He said, that's an infringement on my constitutional authority. You can't order me to reveal classified information. And to this day, that's the position of the executive branch. I think if you ask the Attorney General that, if you ask constitutional law professor Obama that, that's what he would say, that the court cannot order me to refuse. And when, notwithstanding all the lack of oversight, when they amended the oversight legislation for the intelligence community, this president reserved the right. He said, yeah, I'll agree to all of these things. We'll give Congress more, but I reserve the right to exercise my constitutional prerogatives in the right case. So my view is it's a process thing where you give the courts the opportunity to push the executive branch to hold their feet to the fire. And then at the end of the day, at some point, the judge is going to say either he's satisfied or he isn't, and then the burden shifts to the government.
Let me say very, very, very quickly, I am intrigued by the suggestion that we route this to the FISA court, because I actually think that the FISA court judges would be better equipped to solve these sorts of problems. So that solves or mitigates the judicial expertise problem. The judicial role question is a separate one, but I do think that the FISA court is much better equipped to do this than your average run-of-the-mill federal judge.
That's a conversation for another day. Let's do two things. One, please thank our panel for a very good discussion. Second, let's extend a gift to Mr. Jameson for yet gracing us again with his presence here. It's very nice, George. On behalf of Professor Moret, the INSCT, and me, the rest of us here.
Thank you.
Thanks very much for joining us.
Thanks for having us.
All right.
I enjoyed it.
Thanks for coming.